A very exciting and a warm morning to everyone. Today, we are gathered here to celebrate young minds which are stepping up to innovation challenges, using their energy, ingenuity, curiosity, and creativity to steer a course towards a better future. We all are gathered here to learn and steep in the role that intellectual property rights play in encouraging innovation and creativity. In 2023, we celebrate the can-do attitude of women inventors, creators, and entrepreneurs around the world and their groundbreaking work. With the same goal and attitude, we are here organizing this workshop to elucidate our very potential audience. This workshop will be an opportunity for us young people to find out how IP can support our goals, help transform our ideas into reality, generate income, create jobs, and make a positive impact on the world around us. Friends, today we are living in the midst of information revolution. Intellectual property is the result of a conversion of knowledge into a commercial exploitable potential. We have a lot more to learn about this very interesting field, but first, I would like to welcome our honorable guest. It is our extreme honor to have with us Honorable Head of the Institution, Major General Rajendra Kumar, our Deputy Director, Dr. Professor Rakhi Singh Chauhan, revered faculties, and all the participants. I cordially welcome all the students and all other dignitaries who have come to join the first national workshop on generation and commercialization of intellectual property. We all are indeed elated and honored by your presence on this auspicious day. We feel honored to have with us Honorable Director. Sir hardly needs any introduction. He has made all of us proud by his distinguished work in numerous capacities. Major General Rajendra Kumar, AVSM, SM, VSM, an alumni of ILS Law College, Pune and University of Pune, got commissioned into the Department of Judge Advocate General of the Indian Army, which is its judicial wing. During his service in the Indian Army, he conducted numerous court-martial, including those of sensitive nature. He represented the Indian Army in the Supreme Court and various high courts of India. He also took part in various military operations like Operation Vijay and Operation Parakram. He also served in Jammu and Kashmir and northern eastern states for rendering distinguished, meritorious, and extraordinary service beyond the call of duty. He has also been awarded thrice for his excellency by the President of India, conferring him Ati Vishishta Seva Medal on 26 January 2017, Sena Medal on 26 January 2016, Vishishta Seva Medal on 26 January 2009. In addition, he was also awarded commendations once by the Chief of the Army Staff on 15 August 2008, thrice by the Army Commander on 15 August 1994, 15 August 2011, and 15 August 2012 for rendering meritorious and outstanding service in the Indian Army. Later, he rose to the highest rank of Major General in the Department of the Judge Advocate General and retired as the Judge Advocate General of the Indian Army. Now, I would like to invite Honorable Major General Rajendra Kumar to please enlighten the audience with his words of wisdom. Please, sir.
Good morning to all of you. Am I audible?
Yes, sir, you're audible.
But I am not visible. Very rightly, like intellectual property is not visible till it is generated. Similarly, I am not also visible. Now we have got three distinguished guest speakers at National Workshop on Generation and Commercialization of Intellectual Property. Mr. Arpit Kalra, who is associate partner at SS Rana and Company from Noida. Mr. Madhusudan ST, patent attorney, partner at K&S Partners, Bangalore. And Mr. Rodney D. Raida, who is a founding partner, Script Board from Delhi. I, on behalf of Amity Law School and Amity University, Madhya Pradesh, welcome all the three distinguished guest speakers. And you all, the participants, will be benefited by their specialization in intellectual property rights. We have selected this topic for national workshop to facilitate students and researchers to generate and utilize IPRs. This workshop is an effort to build an atmosphere where creativity and innovation are encouraged in public and private sector. They're like R&D, industry and academia, leading to generation of protectable IP that can be commercialized. Now, this workshop, it is intended to reach out to the less visible IP generators like startups and individual inventors, with a special emphasis on the strategies involved in IP commercialization, revenue generation from the strategies adopted, as well as creating IP awareness. It goes without saying that generation and commercialization of intellectual property are very well connected. Intellectual property, as you know, is the brainchild of intellect. Unless until you know the procedure, how to generate patent, etc., you will not be able to even commercialize the intellectual property. First, you have to generate. What is the procedure for generation of intellectual property? Then how to commercialize it? How to reap benefits of your invention? That is commercialization. How to get benefit? Unless until you commercialize through licensing or assignment, till then you will not be able to get any benefit of your invention. So these distinguished speakers will tell you the procedure, how to generate intellectual property and how to commercialize that. And I'm sure you will all pay apt attention to the distinguished speakers and listen them carefully, because this subject, intellectual property, is growing by different bounds in the entire world. So it is very, very important that you should know how to generate IPR, intellectual property, and how to commercialize it. That's also equally important. Since we are already late, I don't want to say anything else. I thank you and wish the conference all success. Thank you.
Thank you so much, sir, for your wise thoughts.
Yes.
Moving ahead, after such a fresh start, now it is this belief in the need for empathy that provides me the cue to humbly invite our very first speaker, Mr. Arpit Kalra. Mr. Arpit Kalra is an associate partner of SS Rana and Company, enrolled with Bar Council of Delhi in 2014. He is working for almost a decade at SS Rana and Company, currently leads the SS Rana and Company's enforcement team. Having an experience in the field of IP prosecution and IP enforcement, he is proficient in all aspects of trademarks, prosecution, as well as misuse of trademarks, handling complex disputes concerning infringement of trademarks, copyright, passing of action, providing legal options related to protection of trademark in India and SAARC countries, as well as other foreign jurisdictions. He has been assisting and guiding various Fortune 500 companies in strategizing, protecting, and monetizing their intellectual property in India and SAARC countries. He is a member of the International Trademark Association for Protection of Intellectual Property in India, Asian Patent Attorney Association, and International Bar Association, and regularly attends the said international and national conferences to broaden the legal horizons. Now, on the behalf of Amity Law School and Institutions Innovation Council, Amity University, Madhya Pradesh, I would like to welcome the speaker of the day, our very honorable guest, to please address the gathering. I would request the participants to drop their queries in the chat box, which will be taken by the speakers at the end. Please, sir.
Good morning, everyone. Thank you, Ankita, for the introduction. Thank you, Major General Rajinder Kaur, for your enlightening speech at the introduction. And this is a perfect start of the day. IP and the benefit, what is the importance, the commercialization, and it's a very unique and a great subject. I hope I'm audible to all.
Yes, sir, you're audible.
So to begin with, I have a short presentation. Let me just share my screen. What intellectual property means. What IP means. As an IP, it's an asset. It's an intangible asset through which one can make money, one can register, one can stop others from using it, having it monetization, one can develop its own commercial goal so that the idea, the concept is protected. So an IP can be registered in various forms, either trademarks, either patents, either designs, or copyright. The method which is there does not embark. Everything has its own objective, that is make money, how to control it, how to stop it, and how to use it. That is the main notion of IP. So like I said, IP registration depends on the type of idea, whether it is a brand, whether it is a logo, whether it is a word, whether it is an invention, it goes for a patent, it's a design, then it will be under the protective design, decorative design, whether it is a trade secret, whether it is an expression of idea, then it go for a copyright. So it depends what type of an idea you choose so that it will have a protection therefore. In this list, what is the benefit of registration of a trademark? The benefit is that by seeing the logo, by seeing the mark, one can identify that yes, this brand denotes to that said company. Any public, anyone, whether a law person or a layman person, it can go, it can see, yes, this is the brand, this is the logo I am looking for. This is the logo which I associate it for. So in this slide, there are various of logos which one can individualize, one can see, one can get associated. Anyone can see whether it is of Cadbury, whether it's of Amazon, whether Unilever, whether Pepsi, whether Swiggy, whether it's Twitter, whether it's Hamleys, whether it is Google. So each logo has its own dynamic. There is no need to mention the whole brand name or a whole company name. Each logo or a trademark denotes its company, and one can easily associate it words. So like there are several types of trademarks. So whether it is a trademark, whether it is of a trademark, whether it is a word mark, whether it is a society mark, whether it is a shape of goods, whether it is a packaging, whether it is a 3D mark, whether it is a sound mark. It's all are trademark correct trademarks. And they all are protected under one law. Herein you can see the very well denotion. One product, each product can have a different varieties and a form of trademark. Either you can protect by way of a name, you can protect your tagline, you can protect your logos, you can go for a symbol, slogans, shape, or a color. These all denotes various forms of trademark protection, and each has its unique right and things. In our day-to-day life, we go into the role of trademarks, right from starting our day till the end. We go through various brands, we use them, but we don't recognize the value. Right from starting till end, we have been using endless of things which has its unique properties, either whether it is a pen or starting a day with a glass of milk or and holding a iPhone or any of the mobile. So it's this never continues. Use of a trademark is such things that IP, right? Everyone is using, exploiting, and using. Another section of trademark is a well-known trademark. Well-known trademark has been defined under Section 21ZG of Trademarks Act 1999. It is that thing which is, though any person can associate regardless of the category of the area or the goods or services. Any person can associate, yes, this is so known to the public that even for any class of things, this is related. Few of the examples of well-known trademarks are displayed on your screens, which are Bisleri. You go to a nearby Panwari or a street stalker saying, you don't say water bottle, you say Bisleri. So that's the brand value. That's the image you have in your mind when you go and purchase the water bottle. Again, similarly, when you used to buy a scooter, you don't say, I want to buy a scooter. You say Bajaj. So even your parents, your elders used to be Bajaj. That's the saying goes, Hamara Bajaj. So there are things, Horlicks for children's, Ordinal, Canon. So these are the small few examples of well-known trademarks. Previously, well-known used to be proprietary by the courts only. It was the courts who would record them as a well-known status. But recently, under the Trademarks Act, you can file an application and obtain well-known right of your trademarks. So the importance is the market share. You have to show market share. You have to show your each plethora of documents, your case that yes, your brand is well known to the public and the trade. Here are the few more examples: Whirlpool, Honda, Pepsi. These are all enjoy huge reputation, huge goodwill, not in India as well as internationally. They are all famous so that even the public can know, yes, Whirlpool has its own, Honda has its name. The few of the downside, which can be like a look-alike well-known. We can just go on and purchase few of the items which are there in the market, and we buying counterfeit. We buy fake products which are not original. But yes, we take pride in using them, in exploiting. Either it be your own Bada Bazaar, Gandhi Bazaar, or in Delhi, you can go for Janpath or Lajpath. You will buy cool Adidas sneakers, though which will not have a pure Adidas, and you will flaunt in months of your students and in your community. Yes, I am buying this Nike, I am buying this Adidas, though you are well aware that it is not original, it is fake, but still we go for that. That is the power of branding. That is the power of IP. That's it is there. You are aware that the brand is not original, but you go for the name, you go for the style, you go for the valuation, the goodwill attached to a brand. To the another facet, that is the patents. So patent is an exclusive ownership right granted to the owner, wherein one can, for an invention, enjoys its exclusivity and prevents them from making it to an invention. So a patent is granted for a term of 20 years, and any person who has obtained it can exclude it, commercialize it, either by way of royalty, either by way of giving a license, or several other measures. There are three important facets of patents. One is it's a unique, novel method composition. It's a process wherein an overall engineering is there. You developed a product which has such a unique and novel process which can have a utility amongst the public. So first thing is invention must not be published in India. So anything you bring in public, the novelty destroys. So before publishing, before making public, before using it, you have to file a patent application. Secondly, the invention must be useful. It should have a use to the public, its utility. Otherwise, it is not. Third, and most important, invention must be different from what it is already known. You have invented a step, but it is not it is not a different product. It is already in the market. It is already known. It is an obvious improvement. So a patent will not be granted. So for a patent, one has to develop an inventive step. It has to go for a utility and what is different. Another facet of things is design. The design and patents go hand in hand. Design is your look and feel. Whether you look at the eyes, whether it is a table, whether it is a jewelry, whether it is any of the design of your mobile cover or your car, you go with the design. One can usually take, yes, what is the design? Design is which is not new, which is original, which is distinguishable from others. Few of the design examples are shape, pattern, lines, and ornament. The basic thumb rule is its appeal to an eye. When in any product, when is applied to an industrial means and it appeals to an eye, and it is not an artistic work or a trademark, it is covered under Design Protection Act of 2000. What is not covered under design? Any of the copied design, like I said, which is similar to the design which is already there in the existence, whether it is already in the manufacturing process or an obscene. So it has to be an original. It has to be unique. It has to be not registered in any country. Another facet is copyright. Copyright, as you must have studied, that there are various forms, either literary, artistic, musical, dramatic, cinematographic, and sound recordings. They are all forms by which copyright protections can be there, different forms. Whether you are writing an article, whether you are writing a poetry, it will fall under the literary. When you are protecting for a musical rights, your notes, it will go for a musical. Whether for a sound recording, whether you have branded a picture, it will go for an artistic work. The important thing again comes what is not protected under copyright. Any facts which is there, which everyone is aware of. An idea, a mere idea is not protected in any form of IP. It is the expression, the medium of idea. It is not the notion, the mathematical calculation, which is not protected under the I. Any of the concepts, methods of operation, titles or plots, you can go for a trademark of a title, but not under the copyright. Any of the inventions or discovery, you can go for a patent, but not under the copyright. So this is what copyright is. Like I said, expression of idea is matters. The copyright does not extend to an idea. It is the pattern. It is the expression. It's there. Few of the movies which have been taken on the concept are there. But yes, it is the concept, not the name, which matters. So copyright is bestowed automatically upon creation of an original work and the documentation and the details related to the original work. Though the copyright or a trademark are all any form of IP is not mandatory to register to get a registration, but it is always advisable because registering a copyright or a trademark, it is one step for a commercialization of your IP. Intellectual property. Through this slide, I want to show that one picture can show you each phase of your IPR protection, whether it is a trademark, whether it is a copyright, whether it is a design, or whether it is a patent. In one picture, And in all scenarios, you can daily witness this, that yes, in each of the things, our IP plays an important role, whether it is a motor vehicle, whether it is any other item. Few of the case laws which are there for the IP protections as the famous one, as Mercedes-Benz case. Here, the defendants have been using a Benz logo for an undergarments. You can see very well the logo of Mercedes, which is a German car, and the Benz logo, which is being created by a person as a three-pointed human being in a ring, denotes the same Mercedes-Benz logo. Though the Benz, the class of goods is different. It's car versus undergarments. But Mercedes holds such a good IP, the valuation, the brand image, the brand goodwill, that they were able to succeed in their claim. Another of the claim is the famous Starbucks versus Starbucks case, where the Starbucks were in a motor and send a letter to the Starbucks coffee for changing their color as well as the name. The both were there. Starbucks has sent a letter to modify the logo as well as the color scheme, and they were changed by making the name change Sardarji Baksh Coffee. So you can see here the copyright, trademark, all were there. You can very well make the notion that how important it's IP, and it is the commercialization of IP. It's not, the benefit is not that by registering one can make. You have to stop others so that one can enjoy our own goodwill, one can enjoy the own monopolization of an IP. This is the third case, where another very famous case, which is Christian Louboutin trade dress case, wherein the plaintiff had registered a red sole footwear as a trade dress, and it's very unique in its end. And a local shoe manufacturer has developed a similar shoe, and they were not allowed. They were located in Mumbai, and they had pleaded that yes, it is not registered, it is not different. But yes, the court has held that it has a uniqueness, it has a brand value. One cannot, the red sole is of Christian Louboutin. So that is an importance of a trademark, that you holds the brand, you goes for evaluation, you go for to stop others for not to develop your IP. Commercialization of a brand. Brands, as you must be aware, serve several significant purposes for business, like acting efficient commercial communication tool for capturing consumer attention. So the main aim is capturing customer attention and serve as an asset to grow for a reputation and business growth. They act as a property which can be purchased, sold, or used as a security to others. Once a brand is created, it should be protected and commercialization. Commercialization is means of a brand essentially refers to making the brand marketable, earning profits through it. And how do we make profit? By using it, by making it to the public. The valuation of a brand lies in the goodwill associated with it. It is an intangible asset of the brand owner's business. What are the various forms of commercialization? First is making a direct use, whether the most obvious, this is the most obvious way to turn a brand into the source of revenue by using it in its own goods and services. Second is by way of licensing. Licensing is a tool through which one brand owner can commercialize their brand without transferring the ownership to a third party, though there are different facets of licensing, whether it is an exclusive license, whether it is a sole license or a non-exclusive one. Exclusive means that you have given right to only one person, and he is the sole person who is there and has a right. Sole license means both licensor as well as the licensee can use the brand, but the licensor is not allowed to license the brand to others. And a non-exclusive license means that there is no binding on the licensor. Licensor can give any license, any number of license to a third parties. So it's denotes. So the best one would be the exclusive license. The third form is franchising. Another, it is nowadays very common. You goes for any franchisee, whether it is McDonald's, whether it is Domino's, whether it is any other chain, clothing chain, or any other chain. You go for a franchising model. Franchisee model is a model wherein a method of distributing goods and services through operated independently, and there is a common identity to the public. Another way or form of commercialization is by way of an assignment. An assignment is a method wherein the one party transfer its right to a different party through its owner rights titles. Though it can be partial or a complete, it depends on the nature of the contract. And another last version is through merger or acquisitions. You have heard that Vodafone and Idea have jointly and have come one. It's VI. Earlier it is Vodafone and Idea. Now it is one company. So they have merged into one company and they are getting the benefit of their IP rights. So it is that form of IP which helps that, yes, the brand is there. Like I said, the worth of a brand lies not only in creating it, but in exploiting it and providing the maximum number of benefit to its owner. Trade licensing, franchising, transfer ownership, and assignments, there are different ways which when businesses can exploit their commercial brands. However, before entering any commercial transaction that involves transfer of rights, it is essential to assign an accurate value to that brand. Proper valuation of brand must be there to determine the future benefits of it. Thus, valuation and commercialization of brands are interlinked concepts, and this is one of the major factors which affects the success or a failure of a business. So I hope my lecture would have enlightened you and have given you some clarity on the thoughts of IP and its rights. Any questions?
Participants, you can drop your question in the chat box. We'll take questions one by one.
So there is a question from Dr. Ragini Kubalkar. How
Okay.
GI help in commercialization process?
I beg your pardon?
How GI help in commercialization process?
GI, geographical indication. So commercialization, like I said, it's any form of IP, whether it is trade secret, whether it is GI. So GI, whether it is like I said, when we go for a Rasagulla, the famous GI, the Kolkata, whether it is go for a rice, whether it is fruit, we go for an yes, we will. I want to have a lychee from Dehradun. I want to have a product from a particular origin. I want to have a sandesh from Kolkata. So that's the benefit that a person has. A person who is aware that yes, this product or a service provided to me in a separate, I would say, in a specific geographical indication, a geographic benefit will have attribute a better value. So it depends on that.
Thank you, sir.
I can see there is one more question, the present term of patents and copyright. The
Yes.
present term, it's very well, you must have read it in your books. The term, the patent is protected for 20 years and copyright is 60 years plus life of a person.
The next question is, can a single color or certain color combination be used as a trademark?
Yes. I think the person has not seen my slide. One of the slides I have mentioned that yes, the combination of a color or a single color can be used as a trademark, and several companies have taken their right.
Yes, sir. Also, sir, there is a question from my side. What is the difference between series mark and associated mark?
A series mark is a specific mark wherein when goes for a word mark or a different type of a variation. When there are types of marks, whether it is a word mark, a single word mark, whether it is a logo, a series. In series mark, there are two types or two variations of a single mark. When protected in a single application, that is a series mark. And an association mark or an associated mark is like there are two marks when not filed in a separate, when filed in a separate application, and when the through its own medium or a registry by way associate it like it's belong to the same person. In series mark, the application is of 2 marks or 3 marks, number of marks in a same application. But for an associated mark, uh, an application can be associated by several others.
Thank you, sir. Also, there's one more question. How do we decide whether an IP has to be protected as a design, copyright, artistic work, or trademark shapes of good?
It depends on the idea, the expression of idea, whether it is a pattern, whether it is a trademark, it is a logo. So it depends on the expression of idea. All the 4 are there, whether it is a design, whether it is copyright, whether it is a trademark or a patent. They all are there. For an invention, you will go for an patents only. You will not go for a trademark. For logos and everything, you will go for the trademark registration. So it depends on the person's need and what's the expression of idea.
Okay, sir. So there's one more question from Priyanshu Soni. What are some recent developments or changes in trademark law, and how do they impact companies and individuals involved in trademark disputes?
In trademark law, there have been regular changes. A concept of well-known has been introduced. A concept of an expedited registration has come into the force, which is a more recent version, wherein usually a trademark registrations takes a longer duration of a time by through filing of an expedited mode. When can a person has to pay an official fees or of around 20,000 more, but yes, the whole process is expedited, and the companies can get their trademarks at a very fast pace and can use them, then monopolize and can commercialize that. So that is the most recent ones.
Okay, sir. Thank you so much.
Thank you.
One more question has been entered in the chat box. What are strategies for conducting a trademark search to ensure that my proposed mark is not already in use by someone else?
The strategies for conducting trademark search, though the Indian IP office has given a free of cost search to a tool. You can go for a public search, you can go and you can search your mark. And for strategies, you have to go for different lawyers who will develop their experience, who will use their experience to know that whether this mark is already known to a public or not. So, and that is what experience counts for. You have to conduct a trademark search. Though IPND has given free, and anyone right from start can do a phonetic version or do a word version, and it depends on the class. So there's this. Thank you.
So if you have time, can I ask more question that I dropped in chat box?
I think I have to leave. I will give one last question. One last question, please.
Sir, what is your opinion about the possibility of overlapping of trademark and copyright?
Overlapping of trademark and copyright. I don't think there is an overlap between copyright and trademarks, though there is an overlap on copyright and design. But uh, for a copyright and a trademark, the both are there, which is their unique process. Both the registrations gives possibilities, given the copyright registration is as mandatory, is though it is not mandatory, but it develops jurisdiction wise, it is benefited. A person who has a copyright registration will have a more stronger jurisdiction, and the trademark registration is unique, like section, you can go for section 29 for an infringement, otherwise under passing off you have to go under section 27. So both has its unique pros and cons.
Thank you so much, sir, for clearing all the questions so thoroughly and for explaining the session in a very good manner. Thank you so much for your wise words, sir.
Thank you.
Thank you so much, sir. Sir, and we are extremely sorry on behalf of ALS that we got some technical glitch, so we could, delay the session. But thank you so much, sir, for accepting our invitation. It was really a pleasure to hear you out. Thank you so much.
Thank you, Shubhangi, once again.
Thank you, sir. Participants, you're just required to wait for a minute. Our second speaker has just joined, and we'll start the second session in a minute.
Yes, ma'am. Yes, I'm doing that. Yes, ma'am. I'm doing that, ma'am. Yes, right away. Hello, can you hear me? I'm right here.
Yes, sir, you're audible.
Yes.
Right. Sorry, I was right. Oh, so from my side, we are ready to start. I have permissions to share the screen, right? Yes, I do.
Yes.
Uh,
Yes, sir. So, Ankita, you can just introduce the speaker, and we'll start with the second session.
Okay. Ma'am. Now moving ahead with this session, I would like to call upon our very next guest, Mr. Rodney D. Ryder, who is a lawyer with over 25 years of experience in technology, data privacy, intellectual property, and new media laws. He is the founding partner of Scriptboard, a full-service commercial law firm with cutting-edge specialization in technology, new media, and intellectual property laws. He is the author of Guide to Cyber Laws, the Information Technology Act 2000, E-commerce, Data Protection, and the Internet, the first section-wise analysis of Indian Information Technology Act 2000. He is presently advisor to the Ministry of Communications and Information Technology, Government of India on the implementation of the Information Technology Act 2000. Mr. Ryder counsels a wide range of clients, from startups to the Fortune 100, and represents them in litigation regarding technology law, data security, compliance with law enforcement, and intellectual property strategy. He is on the board and advisor to the leading companies. He is also regularly interviewed and widely quoted by Indian and international media on technology, intellectual property, and new media laws. Mr. Ryder has been nominated as a leading lawyer in the intellectual property, technology, communications, and media law by Asia Law, Who's Who Legal, Asia Legal 500, among their other international publications. Mr. Ryder has been listed as one of the India's leading lawyers in the 40 under 45 study conducted by Who's Who Legal, United Kingdom. In 2021, Mr. Ryder was listed in Super 50 TMT list of leading TMT lawyers in Asia, published by Asian Legal Business. His second book, Intellectual Property and the Internet, published by LexisNexis, has been acknowledged to be an authoritative work on domain name disputes by the Honorable Supreme Court of India and has been quoted in the first and only judgment by the Honorable Supreme Court of India. He is also an advisor to the National Internet Exchange of India and a member of the panel of independent and neutral arbitrator with NICSI. Words might exhaust, but the knowledge and experience speaks aloud about the proficiency of Mr. Ryder. So, without any delay, now I would like to invite Sir to please address the gathering.
Thank you, ma'am. Thank you so much. My special thanks to Professor Shubhangi Gupta for the invitation. Thank you so much, ma'am. And it is an honor to be here. What I will do is that I have some speaking notes, and I suppose I can speak for, for about 40-45 minutes, if that's all right. And then we can take questions. If it were, a classroom with all of you in front, then I could have, requested you to ask questions at any time. But since it's online, I think it will be probably better if I finish a few things which I have to say, and then we can take questions at the end of it. My grateful thanks to the law school, to Amity University, and hopefully one day I will definitely come down and meet all of you. Of course, if any of you are come to Delhi, please do give me a shout, and it will be an honor to host you for a meal or a cup of tea or something like that. Well, so what we'll do is, with your permission, we'll just go to my speaking notes, which are on the screen before you. And we are going to look at the life cycle of intellectual property with a view on the intellectual asset management model, which has many dimensions, but which is probably the most popular way of looking at intellectual property protection, management, and across the world. Also, I'm going to try and introduce you to the way some of the leading thinkers approach intellectual property from a management perspective. Because after all, we should remember that while we are all in this gathering here today, my assumption is that we are all a majority of lawyers. But all of us at some point, as I have done for the last 25 years in my career, look at clients and their specific problems. The only one caveat that I have before I start is that these are models which have worked for certain industries at certain points of time, as well as certain points in their life cycle. These are not formula which can be picked up at any given time and applied blindly. And that is where the creativity of the lawyer, of the intellectual property counsel also comes into play. Please do remember that. We are looking at the life cycle. First of all, managing intellectual property from concept to commercialization, from start to finish, from idea to commercialization, the entire life cycle. And why is it important for us to look at commercialization? And by commercialization, I'm just using it as a broad term for any strategic use of intellectual property. We are going to take a hard look at intellectual property value, which every business, which every organization must do at some point or the other. The earlier, the sooner, the better. We are going to look at a fundamental concept, the fundamental question of what is the use of intellectual property? What are these wonderful tools that the previous learned speaker spoke about, that all of us are familiar with, but clients always ask us, what is the use? The second theme is the property theme of intellectual property. Are we able to fully and truly roll up our sleeves and relate to intellectual property as property? And then we are going to look at theories in intellectual property management, how some people have presented these ideas, what they have done. And the last part is an interesting thing which we do for our clients as a law firm. We help them with intellectual property harvesting. How to take an idea and look at it from a patenting perspective, look at it from a valuation perspective, look at it from a business impact perspective. So in short, how do we harvest ideas, which is, of course, the full circle of concept to commercialization. So we'll start and go ahead. And at the end of all of this, what I will do is that I will send Professor Shivangi ma'am a copy of this presentation, a copy of these speaking notes, which could be made available to anyone who would like to refer to them, because I feel that many of my questions, whenever I, as a young student or a young lawyer, or even now, attend seminars and conferences, my best questions come a few days later. So if you do have questions a few days later, like I do, then my email address is at the end of the presentation, at the final slide. Please do feel free to drop me a line and I will try my best to answer questions. So the first thing is the intellectual property ecosystem. And do we have a grip, and do we understand, and do our clients understand the creative process? How ideas are born, how to push ideas, and then take the important call as to whether those ideas should be protected or not. Because there are lots of great ideas which do not have any monetary value, which do not have any strategic impact. What do we do? Is it necessary to protect those ideas? What should be done? And these are some questions that we will, and we do regularly try to answer on behalf of and along with our clients. After the protection stage, when we've registered the mark or filed the patent, there is the very important stage of management. Management can come in many ways, as we will discuss. Do we license it? Do we use it ourselves? The last part is the exploitation or commercial exploitation, and we are looking at what kind of impact intellectual property has. Does it give us a competitive advantage? Does it make us better than, or open up avenues, open doors to us that otherwise would not be open? How do we profit from it? And how do we as an organization grow? Because see, if you're advising a company, you have to tell them how intellectual property would make an impact on, say, shareholder value and share prices, on getting an advantage over their rivals, on being able to access new technology. So we'll try to answer these things as we go ahead with some examples. But first, the very important question, what is the use of intellectual property? It's very important for us to understand what intellectual property can do. One, it can put a fence or a wall around your idea. So you look at intellectual property as a fortress with a moat. One of those beautiful Indian forts at Ranthambore or Mehrangarh at Jodhpur, fantastic structures on a hill or on an elevated part of a plain surrounded by moat. So your idea is protected. That is the first reason why we go to register a trademark or file a patent. The other, because you have a wonderful idea, you want to protect it. You want to protect it because protecting that idea gives you extra revenue. It gives you a market position. So if I am Nestle, I want to build this brand of instant noodles around a name like Maggi. So Maggi is my fortress. Income creating. I have patents and I want to lease it, want to license it to others. Patents can be an important source of revenue, as IBM did leverage their entire patent portfolio so much that IBM created another company under, of course, the IBM umbrella called IBM Global Licensing. And IBM Global Licensing every year earns a revenue of billions of dollars just letting others use IBM patents. The third use is strategic, to get competitive advantage. So years and years ago, almost 2 decades plus ago, when Nokia invented the had important patents given on the SIM card, they took those patents and approached the then largest companies, Motorola, Ericsson's, all of that. And they entered into cross licensing because they knew that having a patent on the SIM card wasn't good enough if everybody didn't use it. Also, that patents are like currency, which you exchange, which you could exchange on a business board, the very way in which things are exchanged on the monopoly board. And patents are crucial business monopolies. So to summarize this slide, you must understand the uses. What is your goal? You have intellectual property tools, you have trademarks, patents, designs, but what are you wanting to do with it? What are you trying to achieve? And that is a crucial part of where we are. The important things for lawyers to remember as you would know that intellectual property clearly is property. It belongs to someone just the way real property does. The only difference is that intellectual property is intangible. Uh, it is almost metaphysical. There is the trademark Coca-Cola on a bottle, yet it can be put on thousands, millions, and billions of bottles. And since Coke was founded and the present logo was created, I am sure even the Coca-Cola company does not know precisely how many bottles it has created and generated around the world. So the multiplier effect of this property, granted by government not only in a particular jurisdiction, but around the world. And then we go into international conventions. And that is why many intellectual property theorists tell us that when we think of intellectual property, we must think of it in the international context. That is to say, all intellectual property is international intellectual property. We should not only think about India. We should not only think about our jurisdiction. We should think globally, because intellectual property systems are global. Why intellectual property? Because intellectual property is the best system of incentive, reward, disclosure. Also to handle things like even human rights. So when a vaccine is created, it should be made available to everyone. How do you do that? Through the intellectual property system. So you have a dynamic, adaptable system. It is, at the end of the day, a property contract guaranteed and granted in many cases by the government. And it is possible to opt out. If you do not want intellectual property in some form, if I do not want to make commercial use, I can opt out of commercial rights. Like, for example, I don't want to make money from this presentation. So I send it to your wonderful university, and I tell the professors, please distribute it to anyone who would like to read it. So there is an extent that I've opted out of my economic rights. I may not opt out of my moral rights. For example, I would like this presentation to go out freely to anyone, but my name attached to it. So you get the point that it is possible to use it just the way you use regular property. Do understand that technology plays an impact, and we've got this case study of the evolution of copyright law, or the history of copyright law. My submission is that had there been no technology, there wouldn't have been a copyright law, perhaps. In the beginning, there was no copyright law. So you had the Gurukul stage, or the monastic stage in Europe, where a senior elder person would make juniors learn up books and learn up texts, memorize them, and they in turn would pass it on to their juniors. And that is how books were transmitted before. And of course, towards the end of the stage, people would write it down on some form, but the preserving books was a problem. Books had to be copied. And then you had Johann Gutenberg invent the movable type, which led to the birth of the printing press, and with it, the birth of copyright. Not only the birth of copyright, but other related things like libel and slander, the law of defamation, because now it was possible to make all these works available. And copyright law began to evolve from the Statute of Anne in 1709, if I remember correctly is the date, up till the era of the internet, where anyone can cut, copy, paste. And you have the internet becoming the world's biggest copying machine until it is regulated by a combination of uh, law and technology, which is in the DMCA and other laws. And you have copyright again being challenged through intermediaries and platforms, where value is captured by the platform for works that you do. So all of these things make it a very interesting case study. So do not forget the impact of technology on intellectual property. In terms of copyright, for example, what can be protected? Anything which is original. We need to understand the protection accorded to the author and creator. You need to understand that these rights are not only a bundle of economic rights, territorial rights, which have impact on licensing and other things. You also have the moral rights, the right to be identified as the creator. So long after the copyright term comes to an end, forever and ever, William Shakespeare will be regarded as the author of certain plays and poems. You have the financial reward system in the droit des sous. And you have copyright evolving from medium to medium. Fair use itself and parodies evolved from literature. You can make a parody of a play or a story. It becomes more difficult when you come to photography, and next to impossible when it comes to software. And all of these are protected by copyright law. You also have issues in when it comes to new rights in the new medium. So a famous columnist in the New York Times, Jonathan Tassini, when the New York Times put up their online edition suddenly and took all of Tassini's works, Tassini said, look, you need to take permission from me, because when I wrote these works, the internet wasn't there. So rights in the new medium will accrue only if you have permissions from the original author. So very interesting case. Went all the way up to the Supreme Court, which supported Mr. Tassini's rights. Now we come to literature and a review of some of the literature on intellectual property. One, of course, Paul Goldstein tells us that all intellectual property is international intellectual property. In today's day and age, you can go online and search the Google patent database. It is free of cost, and you can see patents which are being filed in the United States as of now. Why is it important? Because intellectual property has to be placed in the global context. We no longer can think only of India. Because if you look at the international conventions, the international agreements, they are all cross-border. The same principles apply everywhere across the board, across the globe. So that's one important point for us to keep in mind always. When you think of intellectual property, think internationally, not only locally. We have several clients who are looking at newer technology, NFTs, but their trademarks need to be registered on a global scale. We have to do searches across all trademark offices in every jurisdiction that our clients want to do business. And we do it right here. at our computers in our office at Delhi. So this is something which you as younger lawyers, as young law students, need to be aware of. A very important thing, that we are not looking at India alone, we are looking internationally. Second, that intellectual property, a very important book that was written by the IBM Chief Innovation Officer, Kevin Rivet, along with a journalist called David Klein. The book was titled Rembrandts in the Attic. Now, Rembrandt is a famous Dutch painter whose paintings are amongst the most valuable in the world. So the idea is simple. It doesn't refer only to Rembrandt's painting, but it says that if you had a wonderful work of art, you had a Gaitonde or a Sousa in India, or a Rembrandt or a Van Gogh or a Picasso, where would you keep it? In the attic? Now, it's an equivalent. We don't have attics, most of us. We have storerooms. So if you had an expensive painting, would you keep it in your storeroom? No, I mean, surely you would keep it in the drawing room. Of course, me being a poor lawyer, I'd probably sell it off. But whatever you would do, you would definitely not keep it in the storeroom. So when you have a great idea, it is very important to understand what to do with it. First, look at the contours of the intellectual property landscape. Create a thorough inventory of what intellectual property you have. Make sure that your intellectual property strategy is in alignment with the business development, and, like Rivet and Klein say, the IP focus, the IP mindset, putting intellectual property at the heart of your organization. Looking at the patent databases, looking at your own patent database to find hidden treasures, looking at those defensive walls around your intellectual property, watching where your competitors are headed. So if you're in a particular industry, keep a tab on what patents are being filed in your industry. So you have plenty of career opportunities for young lawyers in all of these. And this is the subtext of our discussion. And seek out new areas of protection. For example, the internet. Today, domain names are extremely important as business identifiers. The next important set of literature comes from Susan Harrison and Patrick Sullivan. Edison in the boardroom and Einstein in the boardroom. Organizing yourself to be competitive. Converting intellectual property, converting patents into value, looking at competitiveness, defending intellectual property assets, and of course, guiding and influencing the future. The relationship between invention and innovation for all of us. In the next book is James Boyle's interesting book titled Software and Spleens. And it says that, look, intellectual property is not only is something that you defend and protect, but it is a source of incredible wealth and power in a society which values information. So there is a battle going on at every level. So there is a battle over genetic information. There is a battle over data and the right to privacy. There is a battle between paparazzi and celebrities over the right to publicity. So he gives an example and he says, look, there are so many applications, right from patenting of spleens, which is the organ that cleanses blood, to consumer databases. So there's a war going on everywhere. You should be aware, and so should your clients. When it comes to the internet will probably have the most intense impact on intellectual property, says Jessica Littman. And I tend to agree with her, because intellectual property and technology form a deadly combination. Also, that intellectual property tools and technology tools go hand in hand. Uh, all of you are from a generation where it is possible with a few clicks to search case law databases. 25 years ago, when I joined the profession, that transition was happening. I sat in the library of my first law firm, and there were volumes of case law on the shelves. But on the computer in that library, I could search those volumes within a matter of seconds. That power wasn't available to the generation before me. Do not take these things for granted. Learn how to build from them. And again, look at themes which are international. Thomas Stewart goes beyond the use of the word intellectual property alone, because he says that, look, when you look at intellectual property, you are only looking at what can be registered and what trademarks and what patents you have. He said, look beyond that. Look beyond that to intellectual capital, which is information and knowledge of all kinds. And look at intellectual capital, which is a wider definition: registered, unregistered, protected, unprotected, and use the knowledge in your organization for advantage. So he looks at the knowledge inside any organization, which he calls structural capital. Human capital, the knowledge held by employees. The value of intellectual property as tangible capital. Managing assets and improving internal systems. It may not be licensed or protected in the eyes of the world, but even, and I think Thomas Stewart would be very pleased and impressed with all the Jugaad innovation in India, because that fits into that intellectual capital definition that he has of broader intellectual property. Profiting from intellectual capital, which is a book by Patrick Sullivan, where he talks about intellectual assets and their management. Management is key, because management focuses on a very important concept, which is educating the company and actually going out and executing the idea. So you cannot do either without mapping it first. And of course, there are certain industries where protection is available from creation. Not even, you don't even require to register it. Copyright being a great example. And the copyright industry in India is a massive one. You have films. India produces the largest number of movies in the world. We have television serials. We have so much songs, poetry, writers writing in all languages in India. So all of these are important sources of revenue, and there is an incredible amount of value being generated, not just from the formal entertainment industry, but from the creative industries overall. And this is something which you need to be familiar with. So There are others, Lester Thurow, who's talking about intellectual property in the tech landscape and how the patent system needs to be different for different technologies. And he says that, look, the patent system covers mechanical devices, it covers inventions and software, it covers biotech. He says, surely there should be a different set of concepts. And to an extent, there are, of course, when we look at the way patent examiners are instructed to look at certain patents. But importantly, the needs of industries being different from one another is an important way, because when we look at trademarks from a legal perspective, we tend to think of them only from one perspective. But actually, all intellectual property is also applied intellectual property. And Seth Shulman very importantly tells us the importance of intellectual property when he titled his book Owning the Future. Owning intellectual property is a way of owning the future. After all, trademarks are forever. All you need to do is renew them every 10 years. And we've seen businesses being built around very powerful brands. Coca-Cola is a great example. So those are some of the important theoretical concepts when it comes to commercialization. The thing that we also focus on is taking ideas and generating ideas, protecting them. And we have a format which we work with our clients and which I'd like to share with you today, because when we talk about commercialization, we talk about, of course, licensing, and contracts are very, very important for the way we manage intellectual property. But creating the idea is extremely important. So one is that intellectual capital should be defended. It should be created within the organization. It should be defended. A more progressive view is from closed to open innovation. We are living in an era of open innovation. That means no longer are we focusing on the idea being entirely within a company. We are interested in going out and seeing that our ideas are used by others. I gave you the example of the Nokia SIM card. Nokia was very keen that the SIM card should become the industry standard. A SIM card will only become the industry standard when you reach out to others and when you collaborate. So intellectual property is a very important tool of collaboration as well. Intellectual property needs to be at the core of your business strategy. It's not an optional anymore. And there is a question that I've got on the type screen that, Dr. Agani has sent. He says that, thank you for your contribution about books. Why have you not referred to any Indian author? There are two reasons why. First of all, I have a book on intellectual property and business, which was published by Sage and translated into not only was picked up by a Chinese publisher also. What I thought was that I was looking at path-breaking ideas, and so far, there were two. I think I didn't. There are lots of books on IP as covering IP under Indian law, but I'm not looking at law books. I'm looking at management books. There are one or two. The criteria also was that these other authors have been doing path-breaking work. I did not want to, talk about my book, but since we are talking, then I have a book which is called Intellectual Property and Business, published by Sage Publications, which was translated into Mandarin as well, because the Chinese are very interested in what's happening with intellectual capital around the world. So I guess it's just my apologies. It's just the way my list was structured. There are good books, but these were extremely original. So intellectual asset management systems to create, organize, prioritize, and extract value. So we are not looking only at protecting IP, but what are we going to do? What is the value of these systems? Do we have a system in place? Do we have a process? A process that emphasizes on the creation of new ideas, their organization, priority, so on and so forth. So more than intellectual property, I find that the intellectual asset management or IAM framework is extremely important for us moving forward. What is the organization's commitment to R&D? Are you focused on only on big shots, or are you accumulating the home runs is a American concept from baseball. I've used a combination of both. It's home runs and of course singles and doubles. A lot of people who played cricket also know the scores are built, especially in test match cricket, with a lot of singles and double runs, more than perhaps just the boundary shots. What sort of systems are in place? How and when were the systems developed? Who is responsible for managing the system? Because any company which has been successful has had this sort of a commitment to ideas. What are the ideas, technology for harvesting? Is the strategy for leveraging intellectual assets reactive or proactive? What are the internal conflicts? What are the problems that you face in things? So being honest, is it office politics? Is it red tape? Is it budgeting? What can be done? So this is a very practical, hands-on framework to leveraging, to creating and leveraging intellectual property. So when we look at the business, when we look at the layers, there are going to be a conceptual design layer. There's going to be a production layer where we look at how these ideas are going to be taken to the next level, and there's a transaction level layer, which is many times outside the organization with business partners, with even competitors, and of course with competitors as well. So when we look at innovation, we are looking at a landscape, at a map, and the map is like an iceberg. You can see with the top part being out of the water. That's what the enterprise interacts with, or the business interacts with everyone else. Beneath that, you have other layers which are internal, which are either departmental or interdepartmental. So our business as lawyers is also the management of this knowledge train, or knowledge bus, as I sometimes call it. The feedback loops, developing the product, manufacturing the product, taking it to market, getting the feedback, coming back to the original thing. So these are some of the maps. I will not go into details, but these are the way we've helped clients to look at various models. After all, we are looking at project management. We are looking at managing the way you would a program. And a successful program is um, where you have a constant and hard feedback. What is the use? What are we doing? Where did we want to go? Have we achieved that? If we haven't, then why not? How can we become better the next time? So on and so forth. And we have various checklists. I'll not go into all of them, but understanding each um, unit and understanding each product, preparing the business plan, and of course, auditing that business plan as well. Looking at what we term IP harvesting workshops or invention workshops, where we get an inventor and a group of inventors into the room. We look at opportunities. We look at the teams that are required to address those opportunities, give each participant clear roles and responsibilities, and of course, use creative techniques for collaborative invention. So this is how the invention workshop works. We start in the afternoon, look after lunch and wind up by tea, looking at what kind of opportunities, clarifying what is the latest in a particular field, then starting the next day with a broad vision, looking at broad opportunities, then followed by 2 sessions on looking at precise solutions, and then of course coming out with hopefully inventions and their review. This is not a rigid format, but this is what we have done over the years to help our clients come out with ideas, because generating ideas is the most important thing. How does an organization, and this is the last slide for those who have listened to me patiently, I thank you very much. But what is our role as council? What is our role as part of this team which is managing the idea? One, of course, is our primary role as lawyers, defending the idea, looking at the intellectual property creative system, looking at opportunities to create and defend and generate ideas, secure IP protection, looking at enforcing that idea, acting against infringement. But that's the traditional role of the lawyer. Our role is to step out of that purely traditional role and look at other aspects. One, of course, is the cost, because our clients are always worried about spending too much or too little on intellectual property. Looking at perhaps for certain companies, for certain industries, the role of the chief intellectual property officer. And many international companies are investing in such departments, which goes to answer Professor's question earlier, that why, because many of these things have been successfully deployed, and our job is to look at ideas which have worked. Look at synthesizing, like a beautiful music concert. This whole opportunity to work and play together across industries, across disciplines. A patent for toys may be useful in the manufacturing industry as well. So what kind of opportunities are there? And of course, knowing that intellectual property and ideas are never just for today. They are an important business asset which influences the future course of our industry. Intellectual property is definitely a destiny shaping tool, and you approach it that way, you will definitely benefit from all of these ideas. I hope this has been interesting for all of you. I, of course, welcome questions, but before that, I thank Amity University once again. It's a real honor to be here. I wish, of course, one day in the future that I can definitely visit your beautiful campus, interact in person over a nice cup of tea. Thank you, ma'am. Once again, this presentation I will send to you. And of course, it has my email address as well for you. Thank you so much. Thank all of you. You've been a wonderful crowd. So many participants. And this is credit to your university for putting this program together. Thank you so much. There's a question in the chat box for me. I suppose it's for me. What is the difference between ownership and authorship? Well, the author is the first owner of any work usually, and that right can be transferred. So that's one. Second, that the author of the work will always be recognized as the author, irrespective of the transfer of the economic rights. So, for example, if I write a book, I am the author. The first rights lie with me. I can assign publication rights or other economic rights to a publisher. But there are certain rights that cannot be assigned. That includes the right to be recognized as the author, the right to integrity of the work, so on and so forth. You see, can this presentation be sent? Yeah, that's I don't know which is the workshop group, but I will definitely send it to Professor Shubhangi Gupta, who is my point of contact. I'm sure she'll find a way to send it to all of you.
Yes, sir, I'll circulate the same.
Yeah. What is your view on the abolition of the IPAB? Well, remember that we are talking about a system which is evolving, and there is no one thing which is going to stay the same forever. I would like to see more IP courts. I would like to see more IP specialists deciding certain disputes. I would say that I look at it in a broader framework of the evolution of IP law and procedure. And from that point of view, it is a step in the journey. How would you suggest to curb the lack of awareness? Well, the only the way to curb it is the way your esteemed university is doing it. To just hold awareness workshops, to spread awareness into all parts of our great country, because we have lots of talent. I think the Amity University being present in various parts of the country is a fabulous thing, and a wonderful way to spread awareness. There are lots and lots of things that can be done at the various levels that we operate in. There are things that, for example, I can do and I routinely do. I always try my very best to take up invitations wherever I get. Similarly, I mean, at each one of our levels, we should spread the word. We should tell people about these beautiful tools which are available, about the free resources which are available online. And the more, you're right, the more awareness we have, the greater progress will be made by our great nation. Gauri asks, what would be the right time to register for a trademark of an organization in the path from rock bottom? The best time to register any trademark, ma'am, is now. Whenever you have decided on a name, just go ahead and register. Go ahead and file, I mean. Try and understand whether the mark is registrable or not. It should be unique, it should be memorable. If it falls into all of those criteria and if the mark is available, then go ahead and file right now, even if you think it is in the idea stage. And I personally myself own a number of trademarks. Um, and I had the idea of writing uh, a blog for my stories and poems. So a long time ago, really long time ago, I registered Scribboard as the name of my blog. It came from Scribbleboard. Later, when I decided to set up the law firm, I had the option of using that name for the law firm. And ultimately, of course, sadly, no blog on stories and poems, but I had a registered mark. So if you have a good name or you think it's a good name, go ahead and register right away. Don't wait. What are the facets of IP law that India specifically lacks when compared to the West? Actually, ma'am, very little. We lack very little because of TRIPS. We've been able to enforce, and we have a very good record actually. No matter what a certain organizations would like to tell us, we have a very good record. We've done amazing work. It's not been uniform across all high courts, all jurisdictions within India. That's a little bit of a concern. For example, all the major and important decisions and judgments, for example, have come from the High Court of Delhi, followed by certain other high courts, Bombay, Calcutta, all of that. But certain high courts have not got into the act really nicely. So that's one of the things that in a way we lack, but that's more got to do with, interestingly enough, got to do with your previous question on lack of awareness. The more we make everyone aware, the more it will. Indian companies at the highest level are challenging patents around the world. Our pharmaceutical industry is really doing a wonderful job of taking on Western companies in courts in their jurisdiction and winning. So you have a number of Indian case studies. Again, it boils down, to your previous question. There are lots of successes, but a lot of the time we don't know how successful we are. So I think really awareness is the key. And in terms of the West, culture of innovation, valuing creativity and creative thought, putting a premium on new ideas, encouraging people is something that um, needs to be done at a greater scale. But I would look at that as more things to do rather than a negative of what we lack. We have come a long way, and I am confident that we will go very far. We need to file more and more. We need to respect our own creations. We need to encourage each other. And I think we'll all do a wonderful job. Any other questions? Thank you so much. This is like wonderful set of questions which have come in. I thank each one of the people who asked these questions.
Thank you so much, sir, for us.
Thank you. Thank you.
Thank you so much, sir, for such a wonderful session. I'm sure all the participants are thrilled. Now, with your permission, shall I state the more questions, sir?
Please, sir. Please go ahead.
Sir, one question in chat box from Swati Agarwal. How do you suggest to curb the lack of awareness pertaining to intellectual property rights among general public in India?
No, I've answered all the questions in the chat box.
Okay, sir.
I included this question.
Another question in the WhatsApp group, sir. Can you brief about the DMCA?
Yeah, okay. Well, to be honest, the DMCA will require a special session. So, I can always come back and do that. But jokes apart, yeah. See, if you recall the slide I showed you on technology and the impact on copyright law, it is no longer, it's possible to recognize copyright, and copyright occurs when any original work is fixed in a medium. So for example, when this lecture is recorded, the minute you fix it in a medium. Now, the very early we realized that because of the nature of technology, we needed to give copyright recognition to technology and technical means of protection. So the DMCA is all about recognizing this law and technology combination, recognizing that there will be technology tools to protect and mechanisms to protect copyright. And these needed to be accorded legal status. So that's the DMCA in a nutshell. You have takedown provisions, you have the Digital Millennium Copyright Act addressing all online problems. It's a comprehensive legislation based on the WIPO treaties, and now key provisions of the DMCA, or rather DMCA-like provisions, are also in the Indian Copyright Act as well. So it's important for us to understand this coming together of law and technology. That's my answer in a nutshell. It is the subject matter of a nice half-day training program, if to cover all the aspects.
Another question is, what is digital watermark?
Yeah, so digital watermark is is a tool. So for it's a date and time stamp which I put on a photograph to ensure that I am recognized as the author. So a watermark can be visible or invisible. It's just a way to make sure. Some of the watermarks are functional also. For example, certain watermarks ensure that a particular type of technology interacts with one. So there are functional watermarks, and of course there are watermarks, which is the primary function, which is identifier watermarks, where I put my name and firm and all of that on a photograph. Watermarks are common and popular in the era of photography because a lot of photographs are shared all over, and without many a times without attribution. So it's popular for photographs and videos. More than it is, of course, it's used across the board. It can be used for documents, for PDF files, all of that. But most popular, it is for photographs and videos.
Another question is, can titles and names be the subject of copyright?
See, titles and names are usually protectable by trademarks. Titles, for example, all the titles of J.K. Rowling's Harry Potter series are all trademarks. So the book itself as a literary work is protected by copyright law. But trademarks function better to protect words, to protect taglines, to protect logos, and of course other things, sound marks and so many others, smell marks, musical notes. So the trademark law system. So that is why when we look at intellectual property, we should look at it as a more of a set of utility tools. If you use one tool, it doesn't mean to say you cannot use the other. But some tools are better used or focus on a particular problem better. So, for example, titles, taglines, shorter things are better protected by. They don't effectively get qualified as a literary work. They can be protected under copyright as well. but copyright protection will not be effective as trademark protection.
Another question is, who owns the copyright of work done by freelancers and employee working under higher management?
See, always remember that uh, um, copyright, you must understand the flow. You must understand the that the author always has rights. Certain rights will automatically vest with the employer. A consultant will have all rights until assigned, and therefore we come back to the core question. Copyright and rights under copyright will be assigned or will flow as per an agreement in writing. So all intellectual property, whether it's copyright, patents, trademark, are an exception to the Indian Contract Act of 1872, and which means that there are no oral contracts allowed. The contracts should be in writing and signed by both parties. That means that the focus is on how the contract is going to be drafted. We do not use terms like work for hire or others in India, but all those doctrines are accepted under Indian law. So that will depend on the nature of the agreement ultimately between the employer and the employee. In a classic employment agreement, every work that's prepared or authored by the employee will be the property of the employer. That is something that is understood, but it's always better for organizations to have a proper agreement in place so that the rights can flow and all parties can understand the flow of these rights. Right, sir? Any other questions?
Yes, sir. Yes, sir. There is one last question, sir. Can remix or mashup of songs get copyright protection?
Well, there are ways in which the remakes and remixes of songs are given protection, and you will have to look at the relevant provisions on in the Copyright Act. Section 52 has all of these things listed. There's a way to get permissions, and there's a way to notify the original owner of the copyright. So if a song is more than such and such, or a work is of a certain duration, depending on the jurisdiction you are in, you can reach out, you can take the permission, some works can be done after a particular time, can be done without the permission of the copyright owner. So you can have, say, a jurisdiction where works which are older than 5 years, all you have to do is notify the owner and tell them that, look, sir, look, ma'am, I am going to create this work, and I will share your percentage of royalties, which have been fixed by the statute. In some jurisdictions, you can do a remix the day the song is released. So singer X releases a song, you can do a remix the next day. In some jurisdictions, you have to take permission. Sometimes it depends on the length. So you'll need to understand and have a system that works across jurisdictions. And also now it is important to look at the rights of the artists, of the composers, of the lyricists, and arrange for royalties to be paid for all of them. So this is a very interesting question. Again, something that requires a much longer answer, but in short, the provisions are laid out in law as you would read it.
Thank you, sir. Here we are done with the question answer session. All the questions were briefly answered very well. Thank you so much, sir, for your time and words. We are really elated.
Thank you so much. And once again, I thank Professor Shubhangi ma'am. Thank you, all of you, for being patient. It was a wonderful, welcome. And of course, the way that all of you asked so many questions, it was really, really heartwarming. And like I said, if you have any questions that come to your mind, a day or two later or a week or two later, please do feel free to drop me an email. Thank you all once again. It's been a real pleasure and honor being with you. Thank you so much.
Thank you so much, sir. Sir, it was wonderful to have you. Like, you briefed about the topic very well, all the aspects in relation to commercialization, in relation to the IP management, with proper, authors of the books you related the concept. And I really hope and I really believe that the participants have gained a lot of knowledge from your expertise. That's why so many questions have been put forward by them. Thank you so much, sir, for taking
Thank
up
you,
all the
ma'am.
questions.
Thank you
Thank
so
you,
much,
sir.
ma'am. You're very kind. Thank you, ma'am.
Thank you, sir.
Thank you, all of you. I'll leave the meeting now
Yes.
and wish you all the best for the session ahead and for the days ahead. Thank you so much.
Thanks. Students, participants, you're required to wait for a minute. We'll start with the next session. The speaker has joined. I'll just ask to make the presentation.
So are you able to see the presentation?
Yes,
Yes,
sir,
sir,
your
yes.
screen is visible.
Yes, sir. So before you proceed, thank you for accepting our invitation. I would ask the student coordinator to just introduce the guest speaker, and then we'll proceed with the presentation.
Yeah, great.
Yes.
Now moving ahead with last but not the least session, which will be led by our next honorable guest, Mr. Madhusudan FT, who is an expert in managing of IP in emerging technologies and has experience in managing life cycle of emerging technologies, including autonomous vehicle, AI, robotics, blockchain, etc. He's also a speaker at national and international forums and actively conducts trainings and webinars for R&D teams on various aspects of IP. His area of practice is computers and electronics engineering. Mr. Madhusudan is also an experienced in handling various pre-grant and post-grant oppositions at IPO and managing patent appeals. His number speaks for his achievement. He has experience of more than 15 years of experience with expertise on 9+ subjects and has managed more than 4.5K patents. Now, I would like to invite Mr. Madhusudan to please address the gathering. Please, sir.
Okay, thank you very much, Ankita. Thank you for that such a wonderful introduction. And I would like to thank MIT University for giving this opportunity. Also, Ms. Shubhangi Gupta for reaching out and providing this opportunity to speak before the wonderful audience here. I know that you guys are there from the last couple of hours listening to other topics. I am standing between you and the lunch. but I would really make sure that the topic, the commercialization of IP, I'll make it more interesting. Probably by end of this session, and 1 or 2 key takeaways probably will be there. And I appreciate if you people have any doubts, put it on the chat box, or you can raise your hand. Happy to address. We can keep it more interactive if there is an opportunity. Okay. When we talk about IP commercialization, generally, if you see IP as a life cycle, from the time you create a IP, I assuming that you already know what is IP and types of IP. I'm considering this as a starting point. IP generally mean patents, trademark, copyright, geographical indication, designs, and other types of IPs are available. But majorly, if you look at the industrial perspective, the IPs are patents, trademark, copyright, and designs are heavily used, are leveraged by the companies. When you talk about the IP protection or a life cycle, it starts from innovating the IP. That is from the concepts of developing or conceptualizing the creativity from the inventors, then protecting IP, then commercializing IP, and at the end of the stage is the enforcing the IP. Looking at the third stage here, commercialization of IP, need to understand what is the IP commercialization, what are the benefits it brings to a company. It is very important to understand. So, as I said, IP as a life cycle starts with the protection, creation and protection. Any IP you generate generally incur a lot of cost and time, not only for creating it, but also for protecting that IP. The reason being I generally say it's incur cost and time is you need an expert for drafting or understanding the IP in the first time, then converting that IP into a techno-legal document, because generally IPs, specifically talking about patents, they are a very technical document. That technical document needs to be converted into techno-legal document. For that, you need an expert. The expert generally has to understand both the language of technology at the same time legal. So he is the person or she is the person who is going to draft that application and file it before the patent office. So in that way, it generally costs to the company for protecting their IP. At the same time, it's a time consuming exercise. If you want to draft a quality patent application, it takes anyway 2 to 3 months a time period for to draft a effective patent application and file it before the patent office. In that way, IP protection does incur cost and time. So if you're incurring such kind of a cost and time, definitely you have to reap the benefit from your IP. So I'll talk about how one can make use of their IP to reward for their effort they put in. The second benefit you see in the investment for further research. This is like when you create a IP and commercialize the IP, you generate the revenue out of it. When you generate the revenue out of it, you continue to invest from that revenue for further research. Presently, IP-based companies, they generally invest 2% of their IP revenue for the further research. They invest back to the R&D for researching on their products. So this IP commercialization would help you to do the further research. Third aspect is encouraging new ideas. So you no need to reinvent the wheels. So for example, there is a technology which is already patented, but if a competitor want to build upon the technology, he see that patented technology has a base for his research and start generating new ideas from that. Ultimately, how it benefits to the society, you would end up seeing a lot more options in the market for the same product, and you end up getting the same product in a reasonable rate. That is the objective of encouraging new ideas that would ultimately benefit the people. And it would also help you to generate more IPRs. A company would not sit up protecting only one IP for them. So keep generating new innovations and keep generating and protecting those innovations. So it helps you to generate more and more IPs for a company. And it helps you also build a revenue for future. Just take an example here. IBM is one of the best example we generally give to everybody. Generally, their revenue of $1 billion comes from the IP licensing revenue. You just imagine how big the revenue for IBM, just investing on the IP and getting the benefit out of it. So every year IBM makes more than users $1 billion as a licensing revenue. And another important aspect here, it's not directly from their core technology. They license their non-core technologies for the third parties for manufacturing and selling it. So they have retained their core technology for themselves and they have licensed their non-core technologies. So this is again varies from companies to companies. It based on their business strategy and the goal settings of that particular company. The IP also help you to build a brand. Take an example of Coca-Cola, Pepsi, MRF, Qualcomm. They are the companies would actually develop their brand based on their IPs. For example, Coca-Cola brand is estimated to be worth around $80 billion. It is more than their assets. What you call it as asset here, it could be a company, it could be their employees, or it could be like their various other buildings. It's put together, their asset is very, very less than the asset the IP brings to them. It's close to $80 billion. And also profitability of organization, it increases the profitability of an organization. 2% of patents are used as a basis for forming a new company. Every day you end up seeing one or the other companies are forming. Many of big organizations start forming the spin-offs from there. They use revenue from these 2% of patents to form this new company. So there are just a few examples I would like to wanted to mention here, but there are many other advantages or benefits which attached with commercialization of innovation. Let us understand some of the stats. It's a report by UIPI, European Union of Intellectual Property Organization, and EPO, which is called European Patent Office. They have done the survey between 2007 and 19, which for the SMEs. Look at the stats. It speaks the importance of protecting or creating a IP and commercializing them. Large firms that generally own IPR generate 20% higher revenue per employee. As compared to the counterparts, we don't have IP portfolio. It's a huge 20% revenue per employee is going to be very huge difference. And generally firms that owns IPRs pay an average 19% more salary compared to the firms that don't own any IPs. Similarly, small companies with the IPR portfolio generate 68% higher revenue as compared to other firms, which are in the same category. So just understand the value that IP brings to a particular organization. When we talk about IP commercialization, we always see there is a strong positive relationship between the IPR ownership and performance of the organization. I'll give a few examples down the line in this presentation. But we generally say there is a huge relationship which is positively impacting the companies and their performance. So companies which is owning more than IP, which has IP portfolio build up for them, there is a huge impact on their performance. As I said, IP can be used as a source for generating perpetual income for the organization. So IP commercialization is a tool or a source for generating a revenue, which is a perpetual in nature for any company, which generates the IP, sells that IP, and reuses that IP, the revenue for regenerating the IPs. How an organization can reap the benefit of it? it rewards the creativity. Take an example here. Texas Instrument earns more from licensing its unused patent rights than from its products. So you no need to create a product from your granted patents. You can simply license those patents to your third parties rather than manufacturing it, and it still can make a huge impact on your revenue. Texas Instrument is one of the best example where they generally don't manufacture many of their patented products, but they license it out for the third parties to do that. But their revenue comes from unused this patent is very high compared to their direct products. And it encourages innovation. I'll give a couple of examples immediately after this slide that how this commercialization IP encourages the further innovation. And deter imitation and secure reputation. Just look at this image. It's the image of a Gillette, which is on the left-hand side, and right-hand side is their competitors. See, Gillette had filed almost 22 patent application on just one razor, protecting all around on that particular technology area. They made sure that none of their competitors would build any technology around their Gillette razor. So in that way, what has happened, it deterred the imitation. Till now, nobody is able to copy the technology which are patented by Gillette. And even some people try to copy by adding additional element. Here in this example, look at the red color font. The company Quattro has tried to add another blade, which generally Gillette had a 3-blade razor. And they try to get a patent or commercialize it. The court has found out that even you try to add an additional element for an existing patent, you still consider as a infringement. In that way, even today also none of the companies or competitors to Gillette are able to crack the Gillette's technology. As I said, I'll give a couple of case studies here on encouraging inventions. You can see how one IPR can help you to build an empire, could be in the different technology area. You would have heard Toyota, but very few people have known about Sakichi Toyoda. Sakichi Toyoda, what he has done in 1929, he developed and protected automatic weaving machine. And he realized that he can get a revenue out of from this instead of manufacturing it by selling it to the third party or giving a license. So exactly did the same thing. He licensed this automatic weaving machine technology patents to the third parties, and he generated the revenue. Whatever the revenue has generated from the weaving machine, he has reinvested on Toyota Motor Company. Now, just imagine in 1929, where he has started from an automatic weaving machine, where exactly the company which stands now as a Toyota Motor Company. So what does this have to do with that? What is now a world-class Japanese company? So there is no relation at all with the IPs he has owned. He created one IP, generated the revenue from that. He started altogether new empire. So if there's a vision of a inventor, he wanted to achieve something. So look at the different aspect of innovation, how you can commercialize that innovation. It need not necessary that you develop a patent, you have to continue to work on that same line of technology. You can altogether reinvest that amount you generated into different technology area, and you can still build an empire on that. Second case study I would like to take up. This is a wonderful case study. An individual person. He generally regularly travels across the country in Europe, and he found it very difficult to carry a can opener along with him because that time there are no technologies which anybody can transport the liquids very easily. So herbal crayon phrase, Mr. Phrase invented and patented this flip top can in 1959. And what he has done, he has licensed it to manufacture it to aluminum producer, Alco. So what they have done, they manufactured his patent and then licensed it to one of the brewing company, Pittsburgh Siren City Brewing Company, and they started adopting this patent for their products. There's a tremendous turnaround for their products thereafter. They're able to increase the sale to 233% in a year. Later, he licensed the same patent to Coca-Cola, and rest is the history. You know that what is the revolution it has brought in the food and drink industry. Once this pull tab story, flip top can patent is adopted in the Coca-Cola cans, and sale of beer and soft drinks and led to huge monetary benefit for the owner and patented technology. So I just spoke about the benefits and how IP can be utilized for revenue generation. When you're talking about revenue generation, then there is a immediate question arises. Then how can I do that? What are the ways I can commercialize these IPs? Is one directly by the owner. Take an example of Gillette. They have patented their Gillette technologies. They use those patented products to manufacture and sell it in the market. So that directly by the owner can use the IP for commercialization for their own benefit. Second, I gave an example of Coca-Cola opener by way of assignment. Either you can transfer the rights or license it out to third parties. In that way, you can still get the revenue out of it. You don't need to manufacture here. You don't need to have any manufacturing units or distribution channels. What is that you require it to have a strong patent which can be adaptable by the industries, and they can make use of it for selling the products. So by way of assignment is another option. You can commercialize your patents or the IPs. And by building business partnership, it's a joint ventures where you can cross license each other and build a joint ventureship. You can partner with other product developers, and then you can sell it across. For example, if you come out with a wonderful camera for a mobile phone, then you can directly partner with some of these telecommunication product developers to make use of your camera technology. And in a way, you can also buy some of their patents which can adopt in your smartphones. By doing a joint venture, also you can commercialize these products. So the same thing I talked about, but look at the extreme right side. By business partnership, it could be a way of licensing, or it could be by way of franchising. You would have seen an example of licensing and franchising. Down the line, I'll give you a couple of examples, but franchising, a good example is McDonald's, KFCs. They have given the trade name to be utilized for these IPs. And at the same time, exactly they replicate the businesses of these McDonald's and KFC. Anywhere you go, you find the uniformity in practice. So that is franchising. It can be in the form of joint venture and spin-offs. And you can include IP elements in any other business contracts of that particular third parties. So I spoke about 3 modes of commercialization: by owner itself manufacturing the patented technology. Yes. Anyone has any question? Okay. So I spoke about just minutes ago. There are 3 different types of commercialization. One, by owner itself manufacturing the patented product, patent itself. The second one is by way of assignment. Third one is a license. So in that second aspect of commercialization, assignment, you can assign the patent only once after the patent is granted, or you can assign your application before your patent is granted. Before that, you can go and assign the patent application itself. When the application is in a prosecution stage, you can go and assign your rights to a third party. Assignment before filing the patent application itself. When the invention is conceptualized, but a company or a person has no financial support for filing the patent applications or building a patent portfolio, in that case, they can go ahead and have an agreement with these third parties to assign their rights at that stage itself and get the patent protected by with the help of third parties. So what is the legal stand of assignment? So when you assign the patent or application, the ownership changes permanently. For example, you are the owner of some patents, and when you're assigning the rights, then automatically the third party will become owner of that patent portfolio. It's very similar to what we see in a real estate business. When you buy a piece of property or land, they sell the property to you, you register before the sub-registrar. The property ownership changes from one entity to another entity. It is very similar in the assignment. And you may have to pay the one-time fee. So another way of commercialization I spoke about is license. So in this type of transaction, ownership does not change. The ownership is retained with the patent owner itself. They don't sell the patent here. Instead of that, what they give the license is given for a predefined time period, which is very similar to subleasing your own house. So you sublease it for 1 year, 2 year, 3 years, but ownership still resides with the owner of that particular house. They are very similar to here. Ownership of a patent owner remains with the patent owner itself, but he'll give the license to third party or manufacturers or distributors to use that patented idea and manufacture the products and sell it across. So there can be different types of arrangement between the licensee and licensor. It could be one-time fee arrangement where you say you manufacture 1,000 pieces and give me this amount of fees for me, or every product you manufacture and sell it, I need 2%, 3% of amount from the each product you sell. That could be in the form of royalties for every product. Again, in the license part, you will see the different types of licenses. One is exclusive license. In exclusive license, where a patent owner will give license to only one party, and that party will get the exclusive license for using that patented technology to manufacture and sell it in a particular jurisdiction. In case of non-exclusive license, the patent owner gives the license to multiple parties, more than one. All of them are coexisting in the environment. All of them can manufacture and sell it. It all depends on the internal agreement between the licensor and the multiple licensees, that which jurisdiction they are allowed to manufacture, how many products are allowed to manufacture, what are the prices. So many other things which goes into the agreement between the licensee and licensor in non-exclusive license. And a cross license generally happens between the two big IP companies where they want to mutually make use of their technologies. I gave one example earlier. A company here develops a optimized display for a mobile phone, and a company P develops optimized camera technology for the mobile phone. Now both of them wants make use of this technology in their products so that they give a best user experience. So in that way, company A and company B can cross-license their IPs so that they can compete against the company C. See, in that way, the cross-licensing happens there. If company A owns more patent, then company pay the royalty fee for the difference of number of cases. Take an example, Samsung and Apple. Both of them into the telecommunication devices, mobile phone, and both of them own their IP. It's a huge portfolio both of them own. Recently, they have cross-licensed each of their patents. Apple had a big portfolio in particular technology area. In that way, Samsung ended up paying some differential amount to Apple so that they compensate for the additional patent they have bought it. So keep this in mind. Either you plan to assign or a license your patents. Important is to sign the NDA. If you fail to sign the NDA and started disclosing your patents, started disclosing your terms and condition, then it may backfire in absence of some of the NDA. It could be, for example, if you fail to sign the NDA and you disclose your patents, nuances of the patents to a manufacturer in license agreement, then manufacturer can easily end up not paying the license fee, or he can further sell that idea to someone else because he is not under the obligation of non-disclosure agreement. So in that way, you cannot enforce your right in that case if you don't have a NDA. So it's very important for you to make sure you place an NDA before you disclose your invention to in the form of assignment or license. So franchising I already spoke about. It's all about replicating the franchise's business concept by other entity. You can find n number of franchisees in India with operating the business, which is replicating outside India. Allow use of franchises IP. In this arrangement, franchises can make use of the IP, but they don't own that IP, or they don't able to sublease that IP to someone else. Only they can make use of this IP for the business purpose. So transfer of technology is another way the company or the universities generally can make generate a revenue from the technology. It's from the owner created to another person, or could be the organization. You generally see a transfer of technology between the two different countries in the defense area. So when they purchase these defense flights, generally they end up transferring their technologies. It could be a cross transfer of technology, or one company transferring the technology of particular product to another company. This is one of the ways you can generate the revenue. So transfer of technology generally help to bridge the academy and industry. And it also help you to do the collaborative research end of the day. See, some of the mechanism we have seen earlier, that is how you generate the revenue. But instead of not doing all these activities, you still able to generate the revenue by enforcing your right in the courts of law. So that is the very basic element of IPR creation. So you want to enforce your IPR against the infringers. So what are the important things you need to do in that case when you want to enforce your right against your competitors who are copying your ideas? You need to constantly monitor the IPR. And it is a responsibility of the owner. You need to constantly monitor the IPR, what kind of IPR you're generating, whether the IPR what you're generating is actually protected entire different aspects of particular technology area, or is there any loopholes you have given it to competitors? Generally, when we do landscape analysis, we try to identify the white spaces, gray spaces there. Have you covered that or not? You have to do yourself to identify, is there any white spaces or gray spaces are available for the competitors to sneak in. And also you need to monitor the market and competitors. You need to see who are your competitors, what are their activities, what kind of patents they have protected. Does those patents affect in your manufacturing the products or not? That also is very important you to keep in mind when you're trying to enforce your patents. Keep a watch on infringers. You need to keep a close watch that generally you are selling almost 100 products every month based on your patent, but over the period of time, that number of products which are selling in the market has come down to 50. Then you have to be realizing that there is something is happening behind the scene. That means some third party is copying your product and is selling those products in the market. That's the reason you're not getting the orders for same number what you used to get earlier. So this is your kind of watch you need to keep in on infringers. Important aspect, generally we say patent is a negative right. That means it would not give a rights to practice your invention, but it would give a right to confine upon third parties not to practice your invention. That means you can make sure that third parties don't practice your invention without your permission, but you cannot practice your invention by your own. So that is very important. So you have to ensure that you don't end up infringing someone else's IPR when you're manufacturing the patent. See, these are some of the ways at least an organization can reap the benefits of IP. Creates funding opportunities from investors and government. Any IP generation, you just showcase that you have a number of IP in your portfolio that would automatically help you to attract investors. And also you can go out and seek a funding from the governments. It gives an opportunity for creating licensing, cross-licensing opportunity. And as I said, it helps you to file infringement suit against infringers. It's one of the powerful weapon to generate revenue through patents. You have seen many cases been filed against Apple, Samsung, Qualcomm, particularly Qualcomm filing chip manufacturers, and Ericsson filing the case against Vivo, Micromax. There's so many cases we would have heard in the recent past. It's one of the powerful weapon for a company which owns the IP to generate the revenue. And also to an extent, it gives a freedom to operate by preventing potential competitors from imitating the patented product. As I give an example, Gillette. Gillette, as a patented technology, now they made sure that none of them can touch upon the technology area. So they had the entire freedom to operate, to manufacture that particular product. You don't have a competitors. It will lead to the competition in the market. Some facts on this. Qualcomm generates about 58% of their revenue, that is around 5.7 billion revenue from the sale of Qualcomm designed wireless chips. So this is one of the way you can generate a revenue by licensing it. Honeywell received an award of damage $127 million from Minolta. For the technology, it never commercialized it. It never practiced it, commercialized it. But still they're able to generate the revenue by enforcing their right in the form of infringement. And the third one, as an example, I have given Gillette, which is safeguarded their technology area, the product space itself. So it is important in that case, it's important for a company to align their business goal or strategy with the IP strategy they have in mind. It's very important for any company which wants to commercialize their patent. They should have a suitable business strategy in place so that how the IPs generated by the company will be made use in the future, what kind of forms they want to commercialize, what kind of IPs they want to generate. So there is a good example they have to keep in mind, some of the parameters they have to keep in mind while they drafting the business goals and needs of the organization. So what could be the strategy in that case for a company? It's important to know who owns the base technology in particular area of research. So when you're drafting a strategy, it could be for university, or it could be for small companies or large corporations. It's important to know who are their key competitors, organization filing or acquiring patents in the market segment. So for example, Samsung should know what Ericsson and why ZTEs are doing in their market segment and what they're working on. They can't simply sit on their own technology. They have to be keeping a close watch on competitors. What is that they are working on? How rapidly new innovation space is taking place in the research? Like you have seen artificial intelligence, one of the example. How rapidly this AI is involved in your product development. Where are the opportunities for investment and licensing in your research area? Where are the new and emerging products and technology being developed in your space? which patents are the most valuable or essential for product? Who owns them? Can I go and do the cross licensing? Can I build upon or turn around those patents? These are some of the strategy you need to keep in mind while formulating a strategy for a company. Secure all possible IP. When you're drafting a strategy for a company, you have to make sure that you don't focus only on the one type of IP to protect. Make sure that when the product is developed, you secure all possible IP in that product. It could be a patent, like if you develop a product, what kind of functionality goes beyond that product that you need to protect as a patent. It could be a external appearance. For example, if a company is manufacturing a chair or a bottle, what is the shape? If that shape is very attractive, aesthetic in nature, then you have to make sure that you have to protect that shape of the product as well, not relying only on the functionality of that product. Get your trademark registered. It's very important because tomorrow, if the product is very successful, then the product is known through the brand of that particular product rather than the product itself. We all associate the quality of a particular product through a brand, right? So I'll take an example in subsequent slide. I'll see and indicates that how these IPs plays in the minds of consumers. See, given the option for a consumer, which product you want to buy, which is in the offering in the market. So my first experience, my first immediate ask is, which product looks more beautiful, aesthetic, which looks fits into my living room? I would go ahead with that. So you can have different category of people selecting different type of televisions here. It could be first kind of set of people can select the second product, which looks more appealing. Someone can go for the third one, which is more appealing than first two. So in that way, if it's a end user, they are not really know about what is patent, what is the specification of the product, how actually what is the performance of the product. The first thing they're going to see is the design, how aesthetically it looks, whether it looks really beautiful in my living room or not. Can I impress the people when they visit my home? So that is the first thing comes in mind. It's one of the examples I've taken a television. It could be a mobile phone, it could be a refrigerator, washing machine, be anything, any consumer products. So first thing comes to mind is a design. So important aspect for you to protect here is design when you are confused. Now, you know that the third television is manufactured by Sony. Now, many section of people automatically align towards the third television. The reason being, even I don't know what is that goes behind the television. I don't know whether what is the performance of that particular television, but I blindly select television manufactured by Sony because I directly correlate the value the performance brings by the Sony. So as the brand value, just see if by putting a Sony on the television, automatically it ends up in being in the consumer mind and deters the competition from other two televisions which is in the market. So protecting the brand trademark becomes very important in case of if you want to commercialize your product later. Another example is Samsung. Now people can tilt between Samsung and Sony because there is a section of people who believes in certain brands. So then Samsung will automatically have some competition with Sony. Then people goes to the Samsung. So in that case, the brand value help you to even split the competition and create that kind of mindset that, okay, this product has a high value. It performs really well compared to other television. So protecting brand becomes very important. At the same time, if you are technical savvy, then step ahead, you will start checking what is the functionality, what is the refreshing rate, what is the power consumption, blah, blah, blah. So after that, all the due diligence will end up buying the television. So you understand the kind of IP is playing a role for even one particular product before people buy it. And I said, when you're looking at all possible IP, this is a good example. This robo can have many patents which is attached with the functionality of a robot. It can have an external appearance. It can protect the design of this product. It can have trademark as well. Honda is one of the important trademark which you can protect. Then copyright, the type of source code you have written for the functionality to work, that can be protected as the copyright. So make sure that when you're manufacturing and you're developing a product, when you create a product, all different types of IPs are protected, because every IP can be used in one or the other way to commercialize your patents or IPs. So this is the issue we generally face. You know that there are many IPs are part of your product. IP is also important, but many people don't know when to protect it, right? I conceptualize some idea. I know that it belongs to intellectual property. I can go and protect. But as a traditional approach, IP is not given importance. IP is not given any priority. It's a last importance in the business strategy. Generally, the companies keep. Specifically, I can say it for Indian organizations. What happens if you don't protect as soon as you conceptualized? There is a possibility that your competitors or someone else can be watching your developments. They can copy that idea and start manufacturing it and sell the same product for half of the price you intend to sell it in the market. So as a consumer, I'll go and buy the product which is available for a reasonable cost, a lesser cost. So importance is, as soon as you conceptualize your idea, you need to go ahead and protect the IP. If you don't do that, then you end up losing it for the third parties or copycats to practice it, and then all the effort you have put in generating the new IP, the amount you spend, funding which is gone into developing new IP, will go in drain. This is one of the best scenario you can correlate. If you don't have a IP, then the company which has the largest IP will start eating up. But if there is a IP, then you can stand against a big company. This is what some of the startups are started doing it. So there is a I4I technology. They are able to enforce their patent rights against the Microsoft and get a billions out of as a damage from the Microsoft. Think that if that company had no patents, they wouldn't have stand against these big companies. So IP plays a huge role even coexisting in the competition. So IP commercialization by universities, important to have an IP policy in place. So we generally believe that university are one of the primary and rising source of new knowledge and technologies. This is where a lot of researchers are happening, and many new ideas are conceptualized every day, but there is a lack of awareness as such development of knowledge there. So it is important for university to protect their IPR. So it is important for any university to have a well-documented IP policy for encouraging research and innovation that help you to bring the research to the next level and successfully collaborate between academy and the industries. In absence of such policies, it is very difficult for you to develop such kind of collaborations. Even you collaborate, some of the aspect the university can benefit from IPs would not able to achieve. So what is an IP policy in that case, particularly in the context of universities, institutes? It's a guideline which talks about who is the owner of that IP. It talks about ownership of an IP and what kind of use it provides for the inventors, industries, right to use the IP. Procedure for identification, evaluation, protection, and management of IP. So what are the ways I need to identify the existence of IP? What are the ways and mechanism I need to put in place for evaluation? And then protection of that IP, whether I want to protect as a trademark, copyright, patents, how many patents I need to protect in particular month or a year, what is my target, achievement, those things will go in as a part of this guideline. Procedure for cooperation with third parties. If there is a collaboration with the industry bodies, then it talks about what kind of procedure should be laid down for cooperation with such parties. Guidelines on sharing a profit from successful exploitation. Think that tomorrow you have exploited your patents or the trademarks, whatever it is, in the market, then there must be a guideline on sharing of profit. If the invention is a outcome of collaborative approach between academia and the organization, then there should be a suitable guidelines for organization and university and the sharing of profits. So mechanism to ensure respect for third-party IP rights. That means what kind of respect you showcase to the third-party IPs. Are you IP savvy or not? Are you really care about third-party IPs or not? So this will also tell you what kind of university you are. So IP commercialization by university, important thing to keep in mind is you should have IP policy in place. That is very must. So some of the challenges we have seen the universities are facing in terms of IP creation or monetization is lack of awareness about IP. This is still there in the many of the universities, but so now we have seen there is a transition phase where our government has played a huge role in bringing this awareness in IP in many of the colleges and universities. We have started seeing many universities filing those IPs, but only concern we have is what kind of IP they are filing, how effective those IPs, whether those IP can be commercialized in future or not. Are they infringing third-party IPs in their regular work? Or tomorrow, if they questions the validity of that IP in the court, can those patents be stand? IPs can be stand in the court of law. So this is something we need to worry about. That is a lack of awareness about IP. There is no IP cell nodal person at research institutes. It's like it's left to the mercy of some of the professors or blah, blah, blah. If there's someone is really interested to protect, he would approach the management and try to file the IP. But there is no as such IP seller nodal person, which generally in every company you see IP team, which leads from the front. In case of students project, once the students leaves after submission, then nobody knows what happens to that particular project. There are possibility we have seen in our experience that many projects are developed in universities had a wonderful effect on the regular day-to-day activities, but it is left in vain because people have left the organization, people have left the research institute once the graduation, and that projects are shelved. Publication pressure. Many of the research institute are really showcase the importance and publication than protecting those inventions. So publication first is the policy. It's a huge pressure on some of the professors who regularly invents. They go ahead and publish their research ideas before filing the patent applications. Lack of funds. Not all the universities are well funded. There's a lack of funds. Even there is a funding, they would worry about the regular academic initiatives than creating IPs. No adequate setup to scale up the research. So you need to have suitable labs in place to scale up the innovations. There is not much facilities been provided in the research universities to scale up those research. And there's no guidance on the record keeping. So this is something, the challenges we generally see in case of university in the form of developing IP and commercialization. So Generally, universities can play a huge role in IP commercialization in the form of collaborative research with the companies or in the form of contract research with the companies. As I said, there's abundant knowledge sitting in the research universities. The only thing they have to find the right path or a way to get a reward for such kind of knowledge they develop. So when you do such kind of collaboration activities with the organization, what is the benefit it brings to the universities? It brings the name and prestige for the institute. Going forward, I would believe down the line 5 to 10 years, many of the institutes are known based on their IP portfolio. How does MIT, sorry, how do you MITs, many of some of these universities because of their IP. I create more chances of entrepreneurship and startups. I'll take an example of IASC. IASC has a many incubation centers within the campus. And many of these startups or incubation centers are started by the professor of that IASC. That it give an opportunity for those professors to work like an entrepreneur, develop entrepreneurship and start their own companies and create the employment at the end of the day. And funding. This will help you to attract the funding from the government, or it could be the management, or it could be the investors. It's a good learning experience for research and students. It gives the hands-on experience, industry experience for research and students. A better career opportunity for research, increased scope of research. They are the added benefits by doing collaborative research with the organization in developing, creating IP and commercialization. So this is the IP cycle we generally see. You think creatively. Once you think creatively, you have to protect that IPR. Then once you protected that IPR, commercialization of that IPR is important aspect in the IP life cycle. The reason, if you don't commercialize your product, then you can't further innovate. So not many companies are well funded so that they can continue to get funded for 5 years, 10 years for developing the products. It doesn't work like that. So the investor wants to see the product in 2 years and commercializing that product, generate the revenue from that and start renovating on that product, start building the portfolio on that. So it's a life cycle. You think creatively, protect IPR, commercialize, innovate, then come back. Again, you work upon that innovated product. What is the additional thing I can do on that? Then protect, then commercialize, then innovate. It's a life cycle. It continually rotates around that. So when you're doing all these things, you develop the portfolio, you started the commercializing it, you have to do a IP audit very regularly. What is IP audit? IP audit is a management tool for assessment of the value and the risk involved in such kind of intellectual property assets. It's a tool to help you to assessment of the value of your IP and also what is the risk associated with that. It will help you to do a strength, weakness, opportunity, threat analysis on your IP portfolio. How does it help? It gives a comprehensive picture of existing strategy of the university or a company. What is the strategy around this IP? Whether the IP is growing in the field or the company is growing in that particular core area of a patented product. What is the growth associated with that IP? That you'll get to know through IP auditing. Capacity, whether you have any capacity building for such kind of IPs. And what is the need? So because IP, when you generate, you need to maintain for a longer period. So you need to make sure that whether I need such kind of IP or not, whether I have to renew it or not, I have to still hold good or I need to abandon some kind of IPs. That would help you to do in the IP auditing. And it also oversee the competitive advantage. It helps you to see regularly who are your competitors. Is there any new competition in the market? Do I still stand as a market number one in the market position? Where exactly I stand? That is a competitive advantage. And challenges. It will help you to see what are the challenges being faced by the company. In summary, IP audit help you to answer where are we right now and where we want to head in future. That is what it help you to do. When generally you need to take up this IP auditing, you can do it very periodically, 6 months, 1 year, 3 years, based on the business strategy. Or if any company or university is involving some of the merger and acquisition and joint venture, or if there is any financial transaction is involved in IP, if there is a buying or selling of a division or IP transfer, if you're launching a new product, then you can take up this auditing. IP licensing, particularly during the commercialization time, and if you are claiming for a bankruptcy or if there's any layoffs, that is the time you generally end up doing the IP auditing. So this is the non-exhaustive list. There are many other scenarios where you take up the IP auditing just to realize where exactly company stands. The factors which generally goes in the audit is what is the need for doing this audit, basis of audit, what is the business strategy, what is the importance of IP assets, status of IP management, is it legally valid or non-valid patents, do you want to keep it alive, there is status of IP management, IP dispute, is there any infringement is going on with some of the competitors, financing, is there any financing from the third parties, or are you using this IP for financing in your further R&D? Review of different contracts and agreements. These are the some of the things which help you to do IP analysis, evaluating IP assets, overall review on IP assets and policies, preventing or being prepared for litigation, business strategy formulation. So these are some of the aspects to help you to improve by IP auditing. So in summary, what I would like to tell, if any innovation is developed, it is very important from the time it's been conceptualized, when to file the application, where to file the application, which are the jurisdiction you want to file the application, because patent is a territorial right. If you file a patent in India, it will protect your rights only in India. If you want to enforce your right in different countries, then you have to file the patent in different countries as well, separately. So once you decide your strategy on the creation front, then you have to make sure that what are the different ways I want to commercialize my patents. Because as I said, generating a revenue from the patented inventions are very important for incremental innovations in your technology space. If you don't do that, then your innovation, research and the innovation will halt. Then you don't find the further research will done on that space. So it is very important. You have to practice that life cycle, creation, protection, commercialization, and further research. So this life cycle one should practice, and important aspect is all the mechanism I have talked about today, how exactly we make use of them, each of these stages of life cycle. So that's been to the end of my slides. I'm happy to take up any questions.
Thank you, Shal, for your such a wonderful session. I'm sure all the participants are thrilled. Now, with your permission, shall I state the question?
Yeah, definitely.
Okay, sir. First question is, can you elaborate on SEP?
Give me a second. I'll just stop sharing the screen. I'm unable to do that. Okay.
Sir,
So
can you elaborate?
I believe the question is elaborate SEP, right? SEP is stands for Standard Essential Patent. Generally, you see that SEP in the telecommunication field, which when you call it telecommunication, is a, in layman language, is a mobile application or mobile devices. Standard Essential Patent is when a company develops an innovation and they take it that innovation to the standard setting organizations, they list their innovation as a standard for anyone to practice. That means if someone wants to develop a product, they have to practice this patent. They have to make use of this patent to develop the product. For example, a 5G. In case 5G has to work, there is a various handover technique are used, various concepts are used in the 5G. So in that case, what happens if a company A develops innovations in that particular handover technique, then company B has to make use of that patent to manufacture a product. There is no alternative way of practicing that invention. That means you don't have any other patents which can help you to manufacture the same feature of the product. So if you stand at that particular stage, then that patent will become a standard essential patent. In summary, if I develop a patent and that patent is compulsorily utilized for manufacturing a feature of a product, and there is no alternative way of developing that product or feature, then that patent will be qualified as a standard essential patent.
Sir, another question is elaborate on licensing of SVPs in Internet of Things.
See, SCP, and I believe the people coming from the FRAND here, fair, reasonable, and non-discriminative conditions. See, FRAND is pretty new in India and is also pretty new in some of the jurisdictions like even US and Europe. There is no standard procedure in setting the license for these SCPs. So many things goes in before you come out with what is the standard license fee for SCPs. It could be, there is an argument between the two different schools. One, when you give a SCP license, do I need to give a license on entire product? For example, there's a chip which is being developed, which is used in the mobile phone. That chip is helping you to do better graphic processing of a mobile device. But now that company which has developed a SCP of the chip, they claim a license on entire product. If you sell a product, you pay me the royalty of 1% or 0.5% or 2%, whatever it ultimately court decides based on some of the parameters. They claim that as a SCP license fee. If you're using my SCP patent, you pay me the 1% of your product, every product you sell in the market. But some school of thought is, why should I pay entire royalty fee for my product? Because any product which developed, it includes n number of patents, not only a single patent. Before you develop a product, it can have 100 plus patents in that. And one of the patent is SCP. That SCP is bringing only a 5% of value for my mobile phone. Then I'll give my royalties only for the value that SCP brings, not the value of the product itself. So that is the licensing fee. There is a different way the license fee is being discussed now. It all depends, again, various parameters. What we generally call it as how the company, SCP owners, they have showcased the value, how big the patent portfolio they have. It. Take an example of OI. OI has almost 20,000 SCPs in the field of 5G technology, 4G and 5G technology. Now they go and ask the huge royalty from the mobile manufacturers because they have a huge number of patents. So now the royalty fee again depends on how many patents you have in that particular technology area. So it's a new concept in India, a FRAND, we call it a FRAND license. It based on the various parameters, the court finally decides. Or you can see, we started seeing some of the judgment of European Union being used in India for setting the FRAND license. So in short, license royalty fee paid for SCPs is called licensing for SCP.
Yes, sir. Sir, can you brief about FRAND?
Just I spoke about, FRAND is a fair, reasonable, and non-discriminatory charges. It's Friend, what happens generally when SAP owners files their patent, list their patent as a standard before the standard setting organization, they voluntarily accepts or agrees to license the product or patent to the manufacturers. So that is the prior requirement for you to list your patent as a standard. So when standard owners list their patent as a SEP, they sign an agreement before the standard setting organization. In that standard setting organization, they clearly mention you cannot file an infringement suit against manufacturer of your patent before giving an opportunity for license. So they have to go and propose the negotiation before the SEP users to seek the license. If they fail to get the consensus, or even the SEP users, they don't value the SEP owner, and in spite of that, during the negotiation, they neglect the negotiation and go ahead and manufacture the product, then SEP owner has a right to file the infringement suit. FRAND clearly stand FRAND reasonable and non-discriminative. That means SEP owner should approach the SEP practice users to seek a license before they manufacture or before they file the infringement suit in the court. And this should be, the rate of royalty rate should be very reasonable. It should be in a non-discriminative form. And they cannot make use of dominance of their position, because some of these big companies have a huge dominance in the market. Take an example of Qualcomm or an example of Ericsson or Huawei. They have a huge portfolio. They are the top 5 companies in the 5G, and they start dominating their position, not giving a license or filing an infringement suit against all the parties. That would lead to collapse of system. So in that way, the FRAND makes sure that these companies don't make use of their dominant position against these manufacturers.
So last question. Is there any overlap between protection given to software understand copyright law and patent act?
See, copyright is for the expression, patent is for the functionality. What generally write, the way you write the code for a functionality. Take an example, say functionality can be written in different languages. You can write in C, you can write in C++, in the Java, you can write in different types of programming languages. The kind of expression you have used for writing this particular functionality will qualify as a copyright. But whereas, in spite of you written the same functionality in the different code, automatically the functionality remains same. For example, you can write a functionality in different languages, but functionality remains same. Take an example of capturing an image from a camera. I can write same procedure in C language. I can write the same procedure in Java language. I can call it as a 2 different copyright. But the image you've taken, the functionality used to take the image becomes the patent. So that is the overlap. You can have a different copyright written for the same patent, but you will have only one patent protection for technology.
Here we are done with the question answer session. All the questions were briefed by us very well. Thank you so much, sir, for your time and words.
Thank you so much, sir. Sir, it was really a great pleasure to have you, sir. So with your expertise, knowledge, I really believe that the participants would have gained a lot of knowledge with proper case studies, with the recent examples. You very briefly and lucidly you have explained. Now, for the official vote of thanks, I would like to call Professor Dr. Rakhi Singh Chauhan, the Deputy Director of Amity Law School, Amity University. Please, ma'am.
Thank you so much, Ms. Shubhangi Gupta. It has been such an honor to be part of this wonderful event, the session on generation and commercialization of intellectual property. This is a formal Thanksgiving, although we have no words to thank the entire team. So on behalf of MIT Law School, MIT University, Madhya Pradesh, Gwalior, I would like to extend my heartfelt gratitude, first of all, to Honorable Vice Chancellor, Lieutenant General P.K. Sharma, for always motivating us to do the innovative events. And I extend my gratitude to respected Pro Vice Chancellor, Sir, Professor Dr. M.P. Kaushik, for the guidance. I also thank the Director, MIT Law School, Major General Rajinder Kumar, ABSM, SM, VSM, who always helps us throughout guidance and support, helps us to conduct such events, and he always plays instrumental role in the development of MIT Law School. I express my sincere thanks to all our esteemed guests, Mr. Arpit Kalra, Associate Partner at SS Rana and Company, Mr. Madhusudan ST, Patent Attorney, Partner at KNS Partners Bengaluru, Mr. Rodney D. Ryder, who is Founding Partner Scribe Board. I thank you all on behalf of MIT Law School, MIT University, for imparting the good knowledge, for such a beautiful and brilliant insight, and sparing your valuable time for us. Your guidance is definitely going to support our students in a new direction. So thank you so much for your time and for your guidance. I would fail in my duty if I don't thank Ms. Shubhangi Gupta, Assistant Professor and Coordinator of this knowledgeable program. And this thanks is also extended to her student coordinators team, Ms. Ankita Tiwari, Mr. Divyansh, Mr. Priyanshu Soni, and Ms. Swati Agarwal. I wish to thank all the faculty members and the students who have attended the sessions. And I thank all the IT team members of MIT Noida for throughout support in conducting these events. Thanks a lot to everyone. Thank you.
Thank you so much, ma'am. Now with this, we have come to the end of this informative workshop. So thank you so much, participants, for attending the workshop. These certificates would be provided to you online via mail within a week. So definitely within a week, you will be receiving your certificates. Thank you so much for joining the workshop.